Well, it was an easy decision to predict because it's a decision that no judge wants to make. Viva Frei, Montreal litigator turned YouTuber, and back to some Canadian content for today's vlog. A few weeks ago, I did a video breaking down a lawsuit that was filed by a grouping of small business owners against the Quebec government. It was a lawsuit seeking a safeguard order against the government to declare certain measures that had been implemented, such as curfew and mandatory masks for children, to be unlawful or to suspend application of those laws. In fact, I should put the word laws in quotes because the lawsuit also contested the legitimacy of those orders in that they were issued in virtue of a law for a period of 10 days, then renewed, and the argument was that they were in fact invalid edicts or laws because they never actually went through the required legislative process. I walked you through that lawsuit, I broke it down, and well, the other day they got a judgment and the judgment dismissed the action. Now we will go over a bit of the context in the judgment, but just to start from the beginning and identify who the plaintiff, who the grouping of the plaintiff is. We will go over a little bit more of the context and the nature of the lawsuit when breaking down the decision, but just starting from the beginning, who is the plaintiff? This is from their website, the EAQ, Les Entrepreneurs en Action du Québec, and that doesn't really require a translation, but it means entrepreneurs that are in action in Quebec. Ensemble, défendons les PME du Québec face aux mesures de confinement et d'hygiène excessive du gouvernement. Now that does require a translation, and don't worry, I'm not going to do this with the judgment as a whole, which is entirely in French, but that means together let's defend the PME, which is Petit Moyenne Entreprise, small to medium-sized businesses, against the government's excessive confinement and hygiene measures. Now, before we get into the breakdown of the judgment itself, I think it is necessary for the purposes of this vlog to flesh out in a little greater detail the distinction between a provisional interlocutory injunction or a safeguard order and a permanent injunction. We have talked about it before, but a provisional or interlocutory injunction or a motion for safeguard is something of an exceptional remedy. It is an exceptional, an urgent remedy in that you are asking the court to adjudicate on an issue on an interim basis before they've had a chance to hear the file on the merits. These types of exceptional recourses are meant to preserve the rights of the parties pending a final adjudication on the merits, to preserve the status quo, or to avoid an irreparable harm that cannot be remedied by a final judgment. And so to that end, there are criteria that apply to a motion for provisional interlocutory injunction or a motion for a safeguard order that do not apply to a motion for a permanent injunction. We will get into it in the judgment itself, but in order to succeed on a motion for provisional interlocutory injunction or a motion for safeguard order, you have to prove certain criteria, that being irreparable harm in the absence of the order, balance of inconvenience, color of right, and the public interest. Compared to a permanent injunction where you don't have to prove those four criteria, you just need to prove that you are right in order for the court to issue the permanent injunction. So the burden of proof to some extent is lesser on a permanent injunction in that you just need to prove that you are right. The only problem is that you need to get to a hearing on the merits. You need to have the entire file be heard, which is fundamentally different than when you proceed by way of interlocutory or provisional injunction. In this particular case, the plaintiffs went with a motion for safeguard order, which is the extraordinary remedy that has the additional criteria that need to be met, and the judge said, surprise, surprise, you didn't meet those criteria, so we are dismissing your claim. The claim as relates to the issuance of a safeguard, not the claim on the merits, which they are going to proceed to in due time. All right, with that said, let's get into the judgment itself. Here you have the court information of the Superior Court, District of Quebec, the docket number under the Honorable Jacques Blanchard, JCS, which is Juge à la Cour Supérieure. Here you have the context which describes the situation. I'm not going to read through it. You can freeze frame and read it if you know how to read French. The bottom line, the judge describes the situation, how in March 2020, the government declared a state of emergency and they issued orders under the relevant law, which were good for 10 days, but have been since renewed over and over and over again. The judge goes on to summarize the plaintiff's lawsuit in that the plaintiffs are alleging that these orders that were issued and renewed over and over again are unlawful and that they did not go through the standard and required legislative process, that a free and democratic society cannot operate like this, that the measures being implemented are arbitrary, excessive, and they don't even follow the government's own guidelines, and subsidiarily that the restrictions being imposed are unconstitutional in that they infringe on guaranteed charter rights and cannot be justified in a free and democratic society. And bringing it back to the legal distinction I discussed in the beginning of this video, c'est dans ce contexte que, le 12 mars 2021, les demandeurs saisissent le tribunal d'une demande d'ordonnance de sauvegarde visant essentiellement à obtenir la suspension de divers décrets adoptés par le gouvernement de Québec, voire même leur modification. Translation, it's in this context that on March 12, 2021, the plaintiffs seized the tribunal with a motion for the issuance of a safeguard order that seeks to suspend application of these government regulations and measures or even modify them. The judge then briefly goes over the criteria that are required in order to obtain the issuance of a safeguard order or to declare a government regulation unconstitutional. The applicable criteria to a safeguard order or the suspension of a provision of law that is alleged to be unconstitutional are well known, and are the same as those that are applicable to the issuance of a provisional interlocutory injunction. A. The appearance of the right to the conclusions sought. B. The court order is deemed necessary to prevent serious or irreparable harm in the meantime. C. The balance of the inconveniences favors the issuance of the sought-after court order. And D. There is urgency to intervene. On the issue of the appearance of right, the judge does seem to rightly conclude that there is the appearance of right in that being told you cannot leave your house during certain hours definitely qualifies as constitutional infringements. The question, says the judge, is whether or not these infringements can be justified in a free and democratic society. It seems that question will be a question on the merits of the lawsuit. The judge goes on to analyze the risk of serious or irreparable harm. At this stage of the analysis, the only question is whether or not the refusal to issue the sought-after remedy would be so unfavorable to the interests of the plaintiff that it could not be remedied on final judgment. I am translating, summarizing, and paraphrasing, but that is basically what those paragraphs say. And the judge does go on to recognize that the issuance of some of the safeguard orders would cause some of the plaintiffs to avoid suffering irreparable or serious harm, so they have met that aspect of the criteria. The judge then moves into the third criteria, that of the balance of the inconvenience, and asks whether or not the issuance of the safeguard order would be in the public interest. At paragraph 25, the judge says, at this step, when a plaintiff requires at the stage of the issuance of a safeguard order the suspension of the effects of a law or regulation, the tribunal takes for granted that these regulations or laws target the greater good or the promotion of the public interest without it being necessary to make the proof of that. And then at paragraph 26, the judge says when it's the plaintiffs seeking the suspension of a regulation or law, they must show that the suspension of that regulation or law is in the public interest. And predictably, the judge goes on to say that when it comes to public health measures implemented by the government, it's not up to the courts to second-guess the decisions made by the government. And then at paragraph 46, it says that even though Dr. Bhattacharya says that the situation is getting better in Quebec, it is not imprudent for the court to affirm that the pandemic is still not under control and the risk that the situation gets worse still exists. And then the judge goes on to say something which I think a lot of people are going to find shocking, but perfectly summarizes the attitude of the courts. The judge recognizes that Dr. Bhattacharya says that wearing face masks for children has negative effects on them, but nonetheless recognizes that children play a role in the transmission of the virus. The judge says this to conclude as follows. Bien que ce rôle est limité, précise-t-il, le risque est présent et aussi minime soit-il, il est de trop. Translation, even though this role in the spread is limited, he specifies the risk is present, and as minimal as it is too much. Just let that sink in. It's now no longer a question of how serious the risk is. If there is any risk whatsoever, it is too much, and that is according to the judge's own words. Agree or disagree with it, that seems to be the new standard that the courts are adopting. I forgot to mention that Dr. Bhattacharya was the plaintiff's expert witness who filed an affidavit attesting to the fact that it was in fact in the public interest to suspend some of these restrictions that had been imposed by the government. And in order to come to his conclusion, the judge says, yeah, Dr. Bhattacharya says it would be in the public interest to suspend application of these restrictions, but Dr. Bhattacharya did recognize that there was a minimal risk of spread from children, and any risk is too much, so the children have to wear face masks. Paragraph 49 on the issue of the curfew. According to Dr. Litvak, the curfew as a measure limits the numbers of infections because it constitutes a restriction on social gatherings at specific hours, and was added to the other measures implemented in order to control the spread of the virus. Paragraph 50, the court has to recognize that currently there is no unanimity among scientists as to the method to control the spread of the virus, and the search to find an equilibrium to minimize the socio-economic consequences of the sanitary measures is complex and is constantly evolving. The judge therefore goes on to conclude that the plaintiffs did not meet their evidentiary burden to reverse the presumption that these restrictions were in the public interest. Paragraph 53, the judge goes on just to conclude by specifying that the government did not have the obligation to prove the validity of the laws and regulations because they are presumed to be valid. La demande d'ordonnance de sauvegarde doit donc être rejetée. The request for the issuance of a safeguard order therefore must be rejected. And there you have it. They came, they tried, and they lost because no judge wants to be the judge to make that decision. I don't know if they plan on appealing this decision. I don't think they would have a very good chance on successfully appealing this decision. It is just going to be on to the merits of the dispute, so they'll get a final decision in a year or two. In the meantime, it doesn't look like we're going to get a judicial remedy to all of this, so we might have to get a social or political one. I don't know when the next elections are, but they cannot come soon enough, at the very least, as far as I am concerned. But that is the judgment. I know a lot of you watching this are not going to like this decision, but it is the decision. It is better to know it at the very least. And if you like my videos, you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below because it feeds the algorithm.
That's the joke.
If you want to support the channel, all of these support links are in the pinned comment. We've got all of the standard stuff: PayPal, Patreon, Subscribestar, YouTube membership. We've got merch. This is not merch, actually. La Chaufferie is my brother-in-law's distillery in Granby, Quebec. They make a very good gin and vodka. Robert Barnes and I do weekly live streams every Sunday. We do weekly live streams every Wednesday with a guest. We call it Sidebar with Viva and Barnes. We also have a page on Locals if you want to support us there. It is called vivabarneslaw.locals.com. But more important than any of that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out.